Well, welcome to this news conference. This is about Cy and Ruby's Act, Parental Recognition 2015, Bill 137. I'm Cheri DiNovo. I'm the Member of Provincial Parliament for Parkdale High Park. And this is a bill, of course, that has passed second reading already. We're here today about the court challenge that is going to be happening. And I'm going to let all those amazing women that are up here talk about that. First of all, we've got Joanna Radbourd, family and constitutional lawyer, adjunct professor, McMurtry Fellow at Osgoode Hall Law School. We've got Raquel Grand, parent and applicant in Charter Challenge, next to her. And at the end of this table is Dr. Donna McDonough, who's parent and also an applicant in the Charter Challenge. They're going to be telling you all about it, and of course, will be available for questions after. Joanna.
Ontario's parentage legislation is outdated. It doesn't take into account assisted reproduction. It doesn't acknowledge that there are same-sex parents. It doesn't respect family diversity. It does not protect all children equally. Children of LGBTQ parents do not have prompt, accurate, and secure parental recognition as of right. It isn't equal. It isn't fair. Our children deserve better. So on Friday, April 8th, 21 parents commenced litigation against the Government of Ontario. They are all LGBTQ parents or intended parents, and they want their children to have secure parental recognition. Two of those parents are here on the panel today, Raquel and Donna. Other applicant parents are in the room. Others are busy taking care of their kids. They live in Ottawa, Hamilton, a small town near London, as well as Toronto. They have a total of 12 children. One family has a baby, a week old, super cute. One of the applicant families is pregnant and due in May. They have different family circumstances, but all are united in a common goal: to ensure equality for their kids and all kids of LGBTQ parents. Right now, lesbian couples worry during the birth, not just about the health of the birth mother and the baby, but they're asking legal questions. What would happen if the birth mother died? Could the co-mother take the baby home? Would she be able to get custody? When two women want to have a child together, sometimes they find a friend who agrees to be the sperm donor but doesn't want to be a parent. As a married couple, the two mothers think they can put their names on their child's birth registration. But under the current legislation, they could face a fine of $50,000 or imprisonment for a term of 2 years less a day, or both. Trans men who give birth are expected to show their particulars as mother. This is inaccurate, confusing, discriminatory, offensive. Some dads give birth. Some kids have more than two parents. In 2007, the Court of Appeal for Ontario recognized a three-parent family. The court said there were gaps in parentage legislation. The Children's Law Reform Act was intended to grant equal status for all children, but it was written for a different era. The government has done nothing to fix these gaps that deny equality and place the children of LGBTQ parents at risk. The government knows the legislation discriminates. It knows the legislation is clearly outdated. It knows that the best interests of children are going unprotected. The government says it's committed to making changes, but it has been 10 years since the courts told the government to fix the legislation, and the government still has not meaningfully responded. In the meantime, people keep having kids. And those kids deserve secure parental recognition as of right. In October, in this very room, we had a press conference and warned the government that it was long past time to correct the discrimination. We provided them with proposed legislation that would solve the problems and protect all children. We modeled the bill after British Columbia legislation enacted in 2011. It would let Ontario finally acknowledge modern families. Cy and Ruby's Act would provide equal parental recognition and end discrimination against kids based on the circumstances of their conception. The law of parentage would respect all parents' intentions and their privacy. It would bring security and clarity. It would protect children. The bill passed second reading with all party support, but the government has not moved forward. It seems the government is not willing to take a responsible, principled approach. Instead, we have to spend taxpayer money and use court time to fight for equality. Why would our Premier, a parent, not take more seriously the needs of these children? The applicants invite the Attorney General to settle the case immediately. Let's move forward and give children prompt, accurate parental recognition as of right. It's 2016.
Thank you, Joanna, and we'll move now to Raquel.
Good morning. When I was born, there was never a question of who my legal parents were. From the moment my parents conceived me, no one questioned that I was their child, and together we were a family. I was born, and we belonged to each other. Starting my own family made me realize that these were privileges I would not be able to enjoy without legal counsel and thousands of dollars. My partner, Deanna, and I started our family with the help of a longtime friend of ours, Mike. It was agreed between the three of us that Deanna and I would be the legal parents and Mike would be our backup parent. Deanna became pregnant and our daughter Thora was born. A short while after Thora entered the world, it became obvious that Deanna was badly hemorrhaging from complications giving birth. I stood on the side of the hospital room for 6 hours and held on to our newborn daughter and watched in horror as my wife passed in and out of consciousness, trying not to notice the alarming amount of blood that was accumulating on the floor around her bed in the form of soaked rags, and the panicked scramble of midwives, nurses, and doctors as they tried to gain control of this unpredictable medical situation. More than once, I realized that I may have to raise this little girl on my own, and it dawned on me that I was not even Thora's legal parent, as I had yet to adopt her. Would I even be able to leave the hospital with her if I wasn't her legal mother? Would I be able to adopt my own child if my wife died? Would I lose custody of her if I was not her biological mother? I couldn't legally protect my child if something happened to my partner. In the end, we were very lucky. The doctor was able to stop Deanna's bleeding, and we went home as a family. Deanna was told to remain on bed rest and not go anywhere. That was unnecessary. She had lost a lot of blood and was very weak. Her iron levels were very low. But we still had to contend with the matter that Thora needed to be adopted by me, and Mike had to sign his parental rights over. We set up appointments with lawyers to get Thora's adoption process sorted out, even though Deanna should not have been out of bed. We spent more than a few days and thousands of dollars attending meetings and seeing lawyers for Deanna, Mike, and myself, trying to protect our parental rights. It worked out in the end, and legally we were a family of 3. We decided to have one more child, and I gave birth to Aloe this past August. During the birthing process, Aloe's right shoulder became stuck, and it was a couple of minutes before we were able to deliver her. When she was finally born, she plopped out, blue, and lifeless. My only thought during the next terrifying minute and a half was that my daughter was dead. Oxygen was administered, they got her breathing. She spent the next 5 days in the neonatal intensive care unit. She was placed in an incubator, and I never got to hold her for the first 24 hours of her life. We visited her every day in her little box and spent a lot of time in the NICU. In the end, Aloe recovered and has been given a perfect bill of health. But it was horrible to sit in the NICU worrying for our child and realizing that our family wasn't legally whole. Aloe was born to both of us, but legally she didn't belong to one of us. While we should have been focusing solely on Aloe's care, we had to deal with the added stress of not having all of the legal rights to protect our children and our family. And that's why we need to have all families have the same legal rights.
Thank you, Raquel. Donna.
Good morning. It is with mixed feelings that I'm here. On the one hand, it's an honor to be on the panel with contemporary heroes of mine, Cheri DiNovo, who's introduced and has been stick-handling Cy and Ruby's Bill 137 through the legislature, and Joanna Radbird, whose trailblazing legal endeavors I've admired for a decade. It's also a privilege to be here with other litigants who are making the personal political in an effort to effect long overdue change. On the other hand, I'm terribly disappointed to be here at all. This matter should have been put to rest years ago. With the Rutherford decision in 2006, many, including myself, believed it had. And we believed that the Ontario government got the fundamental notion of a changing, pluralistic, and dynamic landscape of what is meant by family, and that they would want to ensure equality in these rights for all children and their parents. I am the mother of a fabulous 9-year-old. My former partner is the biological mother. I was so pleased that the LGBTQ community had won the Rutherford case so that I was not required to formally adopt my own child, something lesbian friends whose children were born in the 90s were forced to do at a cost of thousands of dollars. On our daughter's statement of live birth, I am specifically named as a parent. Our daughter was the first baby in Ottawa to be immediately registered with the particulars of same-sex parents, something that was celebrated by family and friends. At the time of registering her birth, I was under the impression that in accordance with Justice Rivard's decision in Rutherford, my parental status was legally acknowledged for all purposes. Unfortunately, my understanding of the scope of the ruling was mistaken. This devastating realization was made very apparent to me after our separation. There are discrepancies in definitions and legal loopholes in parental recognition. I have been a victim of the government's failure to responsibly address these problems. Because of their inaction, the bitter irony is that rather than improve and protect my status, Rutherford made me more vulnerable. The question of my legal status as a parent plagued me throughout the custody proceedings, diminishing my position and setting the stage so that I was constantly having to spend precious time, emotional energy, and money to prove my equality. The final financial cost of this legal battle was in the hundreds of thousands of dollars. The debt is enormous and will take the rest of my working years to pay back. More importantly, though, this is a human rights issue of fundamental importance to the well-being of children. It is in our children's best interests to have the security, the certainty and safety that comes with having all their parents recognized as their parents at birth. Appropriate and accurate recognition of their families is always in children's best interests. As a psychologist, I am acutely aware of vulnerability and protective factors for children. Among the things that figure prominently are 1, a sense of identity, and 2, an absence of conflict. I know this as a psychologist, and I live it as a mother. A sense of identity does not solely come from a molecule, biology, or genetic matter. It comes from security and stability. It comes from attachment and relationship. It comes from love. So the fact that all our children know who their parents are, and they have certainty around that, and that they know that nobody can disrupt that, that is very important for children's well-being. It is fundamental. As for conflict, and how this can be detrimental to children's best interests, there is an abundance of scholarly literature and research on this topic in relation to children and family, and unfortunately, to custody. And the vast majority of it comes from heteronormative family structures. High conflict custody cases are far more prevalent in heteronormative scenarios than in a scenario like mine. Wherever they exist, though, these cases present a sad testament to our legal system and to the best interests of children. It is not uncommon in such cases that there are attempts to maximize and manipulate strategic advantages. What makes my situation unique is not that it involved a same-sex couple necessarily, but that the legislative contradictions provided the playing field and as a result afforded me a discriminatory and disadvantaged position. Let me use a baseball analogy to describe what it felt like to have to navigate legislative contradictions and inconsistencies in parental recognition before the court. It's kind of timely with the Blue Jays home opener this past weekend. Throughout my 2-year court struggle, it felt that the other team was out on the field already for custody and access, and I could not get anywhere near the stadium. Instead, I was jumping through hurdles and hoops, desperately trying to convince the gatekeepers that I had to enter, pleading with them that I was legit, that I was a parent. There were times when a judge would interpret the spirit of the law in a way that let me through a gate or two, but by the time I finally got to the dugout, I was exhausted. And it felt like the umpire expected me to be grateful that I was even there at all. To this day, I'm not sure how I was still standing at that point, but every parent knows just how far we can reach when we're fighting for our lives, for the lives of our children. How did it end? Well, I have my declaration of parentage and joint custody and equal access, so I like to think that it's a tie. But is it really? Most parents don't need declarations of parentage. They are recognized at birth, and it isn't over. We're in extra innings. I live under the constant threat of being pulled back into court, where I'm still struggling to be recognized substantively as equal. The government's failure to properly amend the Children's Law Reform Act following Rutherford had very real implications in my legal battle for shared and equal custody and access. It facilitated discriminatory arguments, lengthened and complicated an already high-conflict family law proceeding, and imperiled the best interests of our child. The Charter guarantees equality to all children, whatever the circumstances of their conception. Both of my daughter's parents should have had full and secure recognition, as would have been in her best interests. Instead, despite Rutherford, I continued to face non-recognition of my parentage and ongoing discrimination. I cannot encapsulate in words the emotional toll and financial devastation the government's inaction has exacted on my life and ultimately on my daughter's. There are no words. It is beyond general comprehension. No other parent should have to go through this experience. That is why I am here today. In a province as diverse as Ontario, the concept of a chosen family is not uncommon. To legally recognize these seems obvious. The Government of Ontario must acknowledge and validate the reality of diverse family structures. There must be no two-tiered parenting. There must be equity within and across family structures. Full parental status, full parental recognition and responsibilities. I hope that this charter challenge will ensure that the government's response to the constitutional violation actually ends discrimination against LGBTQ families for our children's sake.
Thank you, Donna. Just to sum up then, as you know, Bill 137 has passed second reading with all party support. Since then, I've been in conversation with the Attorney General and her office, Madame Meilleur, and also with Yasser Naqvi, the House Leader, as with others on the government side. And they keep saying they're going to be working on this, but we've been waiting months now. The reality is that it is completely and utterly up to them to get it to committee and out of committee and make it law. And that's the ask. We're asking them to make it law. The fact that this charter challenge has to go forward is in itself a shame. This could be dealt with, and it could be dealt with easily. It's clearly discriminatory. Get on with it. Change the law. Are there any questions?
I was just going to ask if you could make some more links to me for this challenge and the bill. So they're not pushing it forward to committee. So was this charter challenge specifically intended to light a fire?
Well,
Is there a dual purpose? Or just,
I mean, the charter, I will let Joanna talk about this, of course, but the charter challenge is necessary because the law remains the law and because the government hasn't acted to change it. If they acted to change it, we wouldn't need the charter challenge. It's as simple as that. And all the time, money, and effort of the parents involved and Joanna would not be necessary if the law changed.
Can you get a sense why they're dragging their feet? Like, has there been any delay, because sometimes like a private member's supposed to be like, oh, we have to, redraft this part for it to be in order or something.
Yeah, thanks for that, Ashley. No, we're looking at it. Yes, we're moving on. We're going to do, there were some small questions, but Those were resolved, so there really has been no answer. It's a mystery, so perhaps you can ask them, and I would advise that you do so.
So the Rutherford decision was 2008?
6.
6, so we're going on a decade.
It is a decade that the government has known that its legislation is unconstitutional and needs to be changed. Justice Rivard in Rutherford made it very clear that LGBTQ parents were suffering discrimination, and the government amended a regulation and did as little as possible, but didn't effectively address what parentage means. So we have, it's heavy on my heart when Donna describes her experience. We have parents trusting that the government has corrected the discrimination, and instead they just rely on a birth registration that does not give their family security. So children continue to be at risk because the government has not acted after a decade of being told by the courts that its legislation is unacceptable.
So who's involved in this charter challenge? Sorry, I came in a couple minutes late.
We have 21 parents who have a total of 12 kids. We also have people trying to conceive, and we have someone who's pregnant and due to give birth in May. So LGBTQ people continue to have kids, but don't have secure parental recognition.
And the key is always if you know the donor, right?
Yeah, so this is the common misconception because Rutherford involved lesbian co-mothers who had used unknown donor sperm. And we ostensibly win that case. The government makes a change. And the regulation does say that if you've used unknown donor sperm, both mothers can show their particulars on the birth registration. But that's just the piece of paper that's very useful for enrolling your child at school or crossing a border. It doesn't give you, though, secure parental recognition because under the Children's Law Reform Act, the definition of parent requires a biological link or an adoption order. Because of Rutherford, now, why would you spend thousands of dollars to get an adoption order when you see both mothers' names on the birth registration? So people think that they're protected, but they're not actually protected because the definition of parentage under the Children's Law Reform Act remains heterosexist. The government didn't bother to fix the legislation that defines parentage. Then for couples who've used known donor sperm, even if they're married, they can't show both mothers' particulars on the birth registration. They have to act as though they're a single parent, and then they have to pursue either an adoption or a declaration of parentage, which costs them thousands of dollars and which causes delay. And there's risk to the child in the interim before you can get that order. And then there's the offense to dignity of, why should we have to adopt our own child? We had this child together. We conceived of having a child together. We've been through the pregnancy together. This is our child. So why should we have to adopt our own child?
So what if someone's using an egg donor and a surrogate? Is it the same applies?
The fact is that straight people who use donor gametes, whether donor sperm or donor egg, put down their particulars on the child's birth registration based on the intended parents. It's only LGBTQ parents who have to go to court and spend thousands of dollars. The government has not explained why they've taken this discriminatory approach because it was clear in Rutherford that the court was finding that parentage is not exclusively about biology. It's also about social parentage and recognizing the equality of all children.
Alison wanted to ask.
I was just going to ask if Cy and Ruby's Act were to be come into force, how specifically would things look? How would things be different?
So with Cy and Ruby's Act, all the parents' intentions would be recognized so that children would have equal recognition. If you have lesbian co-mothers who've used unknown donor sperm, they get full parental recognition. If they've used a known donor and they have an agreement prior to conception, they have full parental recognition. Trans men who give birth can put their particulars down, self-identifying as father to their child. And then we had in 2007, the Ontario Court of Appeal recognized a 3-parent family. Multiple parent families would be able to put down their particulars on their child's birth registration where they have an agreement prior to conception. So it's about honoring a child's family as the child's family is created, rather than imposing heterosexist norms and demanding that all families look the same.
And British Columbia, for example, and Alberta, but British Columbia more so is a good place to look in terms of precedent on this.
And this agreement, would it have any, are there any limitations on what the agreement could look like and what it has to contain? You did say pre-conception, so anything done after the conception might not work.
Yeah, so it would still be possible with Cy and Ruby's Act to have a declaration of parentage to deal with other situations. But the idea is that when everyone comes into parentage together with an intention to parent together, that they should have immediate parental recognition instead of having to spend thousands of dollars and go to court.
But LGBTQ parents will still have to go and get that agreement and pay for that agreement, whereas a hetero family does not have to.
It doesn't say anything about having to get a legal agreement that would be 20 pages long and cost thousands of dollars, which people currently do. It reconceptualizes what parentage means so that there would be an acceptance that social parentage, intended parentage is parentage. So there wouldn't be the same insecurity around having to get legal advice and spend thousands of dollars in order to recognize already existing parental status.
I mean, the bottom line is heterosexual parents don't need to think about all of this.
Even if they're using donors, like it.
Yeah. So it's clearly, and it has been ruled, as Joanna said, twice now. It's discriminatory. The courts have said so. They've said it. It's 10 years. What's the problem with the government changing the rules to, really recognize what the courts have said is true, that this is discriminatory, and it is discriminatory. So again, it seems a simple thing to do, a simple thing to ask, and we're mystified that the government hasn't acted.
So the backgrounder specifically talks a lot about lesbian couples, but if a gay couple uses a known egg donor, the same legal limbo applies?
So right now with surrogacy, although you're supposed to do a birth registration within 30 days of the birth, the Ontario Registrar General asks parents not to comply with that requirement and instead hold off on doing the birth registration. And then those parents, intended parents, go to court. They get a declaration of parentage that acknowledges the intended parents as the parents of the child.
And that's regardless of the sexual orientation of the couple involved in the
Yes.
surrogacy?
Yes, that's right. So that we didn't change with Cy and Ruby's Act. That's the same. We've maintained the same regime.
And I just wanted to point out that the voice in the background is Aloes. The small voice in the background is Aloes. Thank you very much for coming. Thank you. Sure, Ashley.
In October, I just went back to the story about then. You guys made it seem like it doesn't matter the sexual orientation of the couple if they use a known sperm donor. So it does matter?
Well, there's a difference between what it says and what happens in practice. So in practice, we know that straight couples that use known donors don't bother to to go to court and to get parental recognition that way, that it's exclusively an LGBTQ problem. The fact is, we can't conceal that we access donor gametes, and straight people can. They can keep it a secret, and so no one would ever know. So they aren't concerned about if some relative dies and writes a will that says that the money is going to go to all of my nieces and nephews. Straight people, well, everyone thinks that's the niece, that's the nephew, and nobody's going to question it. Whereas if it's a same-sex couple, then although they have presumptive proof of parentage because they've put both their names on the birth registration, say, if it was an unknown donor, they don't have definitive proof. And that means someone can say, oh, there's proof to the contrary. There's no biological relationship here. And so for estate's purposes, niece and nephew doesn't include you because although you've always acted as niece and nephew to the deceased, actually biologically you're not. And so you're going to be cut out of inheritance.
We're going to have to stop the press conference now, but, we're all available after.